I salute you all. Thanks for watching and thanks for being on. And subscribe and like the videos. So basically, today we are under administrative law. Administrative law as a course unit basically. And what you have to bear in mind, or what you have to put in mind, is that we are looking specifically on the topic of natural justice. You get, that's the topic that we are going to look at in its broad. And what I can tell you about natural justice is that natural justice is like the sugar in the judiciary, or in the judicial decisions, or in any judicial judgment. It is the sugar, it is the catalyst, it is the fairness, it is the reasonableness, it is the equity in the judicial system, or in the judicial cases. That's the brief that I can talk about what? Natural justice. Natural justice, basically, as you hear the word natural justice, it is there to bring justice in trial, justice in conviction, justice everywhere. That is to deal with what? To deal with natural justice. And what you have to bear in mind, natural justice has two rules, two specific principles. They are not even rules, but they are principles, because it moves with these two principles. There is the principle that is called what? There are two principles. And there is a principle that is called Audi Alteram Pattern. Audi Alteram Pattern, this is the principle English-wise. It is the principle of what? The rule of fair hearing, or the rule to be heard, or the right to be heard. You get? That is Audi Alteram Pattern. And there is what they call, there is also a rule that is, also it is in Latin, it is called Nemo Judax in Causa Sua. That is also in Latin. Nemo Judax in Causa Sua. That is the rule against bias. That is the rule against bias. So those are the two principles. They are the two specific principles that natural justice moves with, or that natural justice moves. So put that in mind, or bear that in what? In mind. Those are the two rules. So we shall start with the first principle, which is the right to be heard, or the right of fair hearing, which the right of fair hearing, which is Audi Alteram Pattern in Latin. So basically, under this right, as you hear, the right of fair hearing, or the right to be heard, is that anybody that is being accused is given an opportunity to hear his story, or to hear what could be the cause. You understand? So put that in mind, to hear what could be the cause, what could be the problem, or what could be anything that made him to do what he is being convicted, or is being charged of. So we shall start with the rule to be heard, or the right to be heard. So put in mind. So under the rule to be heard, or the rule to be heard, or the right to be heard, the good case that can define it is the case of Ridge versus Bloodwin. Ridge versus Bloodwin. So put that case in mind, the case of Ridge versus Blindwin, because basically here in that case it was the Brighton Committee. It's an England case. There's a Brighton Watch Committee that was put in place. It was responsible for for the enforcement of discipline in the police force. It basically dismissed the chief constable of Brighton from office without giving notice, or offering a hearing. You get? So as a result, the court held the decision was void due to the fact that the person wasn't given a right to be heard. You understand? So that case is the one that drives that principle to be heard. You get? So that is the good case about this principle that we are talking about. But however, this principle has various elements under it. This principle, or right to be heard, or right of fair hearing, which is Audi Alteram Pattern. And one of the elements, we have the element of notice. The person being questionable, or the person that is being charged, must be given a notice. What do we mean that a notice? We understand the term notice is that you are told, you are notified, you understand, on the substance of the allegations of the charge, and the time. Actually, even the time must be specified and the place where the hearing must be what? Must take place. You are given a notice on the charges, you are given the notice on the time of the hearing, you are given a notice on the place where the hearing will take place. The good case relates under this element the case of Disouza versus Tanga Town Council. That is a good case. Disouza versus Tanga Town Council of 1961. So that is a good case related to the same. So when you move further, there is also another element under the right to be heard. There's an element, the right to know the opposing case. What do I mean by the right to know the opposing case? Is that's why when you reach to court, the prosecution must give the charges or what the alleges or the evidence, you understand, that is having against me if I'm the one that's being accused. They give me that evidence to read it through so that I can know what is the opposing case really. What evidence do they have? What are they really opposing? My what? Innocence. You understand? The good case is Kanda versus the government of Malaysia. That is also a good case of 1962. So put that in mind or bear that in what? In mind. You get? And actually, when you read even that case, they stated that the right to be heard is to be a real right, which worth anything, or it must, the accused must be aware of the opposing case so that he gets what? A fair hearing, so that he can also submit, he can also interject, he can also add and subtract on the evidence that is being what? All the statements that are being put in the opposing what? Case. And he must be given a fair opportunity to correct and contradict them. So basically that's what that case brings out, or that's what the case portrays under the right to know the opposing case. Then there is also the element of what? The element of adjournment. What do I mean by the element of adjournment? The reason as to why I say that there is the element of adjournment is that sometimes we realize that the person being charged has no sufficient evidence or argument towards the case that they are accusing him or her. So he can ask court to adjourn. We have seen this. The council can ask for adjournment so that they can prepare and come back so that they can also submit. So that is the right of adjournment is also there. So that case works upon the case of Kanda versus the government of Malaysia. So that is also a good case still. When we realize that it is also good what? It is also a good case. So adjournment is also an element under what? The right to be to a fair hearing. Then basically we also have another element. We have oral hearing. What do we mean by oral hearing is that you are brought in front of the tribunal or in front of the court. And basically what you have to bear in mind is that they hear you submit on the rejection or anything else. That is a oral hearing. Orally, you are given platform, you are given the podium, and you come to in front of the panel of the tribunal or the judges of court, and you are heard upon the case that you are having. The good case is the case of Ara versus Immigration Tribunal. That is a good case on oral hearing. Then another element that I can put ahead is the element of witnesses. Witnesses, they are also key under what? Adjournment. What do I mean that witnesses? Some people cannot defend themselves, but they can use witnesses. I realize that some evidence needs to be what? Needs to be corroborated. You realize that they must give you audience to allow witnesses to be questioned, cross-examined, among others. You understand? So that they can bring out that principle of a fair what? A fair hearing, or a right to a fair what? Hearing. So put that in mind, or bear that in what? In mind. There is also another element that I can talk about, the element of, before even going further, on the right of witnesses, there is a case of Cleon University versus Fernando. That is a good case. Then there's also an element of what? The element of a duty to give reasons. You have a duty to give reasons as to why. You understand? So giving reasons is one of the fundamentals of a good administrations. You understand? If you are to make a judgment, give reasons as to why. Don't just say that he's guilty without any reason. So the duty of reasons is also necessary to bring out the principle of natural justice and also the principle of what? Of the right to be heard. You get? Which is Audi Alteram Patan. So bear that in mind or put that in mind. And also there is also an element of legal representation. Legal representation is also mandated under Article 28 of the 1995 Constitution of the Republic of Uganda. Legal representation. You must be given that platform. You must be given that right to be legally represented in the courts of law. You understand? So put that in mind. That is also an element. You get? The case of Pet versus Greyhound Racing Association brings it all. Then we have also the element of disclosure of relevant information. There must be disclosure. So put that in mind. What do I mean by disclosure is that to reach to any decision, they should inform the person on the grounds, you understand, upon which they are supposed to act and give him an opportunity of being heard in his own what? Defense. So bear that in mind. The case of Reed versus Bloodwing, it is also good. The leading case that is still on this principle, it is also very, very good on the duty of what? Disclosure. And there is also duty of appeal. What do I mean by appeal? What do I mean by appeal? Appeal is that, realize that everyone has a right to appeal to a higher court or to a higher tribunal. You understand? If you are dissatisfied of the decision of the lower tribunal or the lower court, you can appeal in the higher what? Court or tribunal. So that is also an element of fair hearing or an element of natural justice. The case of Lloyd versus McMahon, that is a good case. Mark of MC. So that is also a good case on the right of appeal, whereby they say that an appeal is a requirement for what? For fairness. You understand? An appeal is a right of fairness. It is a requirement, a right of fairness. Demand when anybody, domestic, administrative, or judicial, has to make what? A decision which will affect the rights of the what? The rights of the people or the rights of the individuals. So put that in mind, the right to appeal. So basically that's what I can talk about the right to a fair hearing or the principle of natural justice. We have done with the principle of to be heard, which is Audi Alteram Patan. That principle is done, and its element we have seen them. So we shall go to the next principle, which is the rule against bias. You understand? This rule is known as Nemo Judex in Causa Sua. So basically bear in mind, it is not a Chinese word, but it is a Latin word. So basically it is a rule against bias, whereby they say a person cannot be a judge in his own case. So that is that saying, a person cannot be a judge in his own case. Basically, if a person is a judge in his own case, basically the case will go what? Will go in his or her favor. So this is the rule against bias. You understand? So put that in mind or bear that in mind. And basically here what you have to know. So basically, as I'm talking about this principle, it has also two elements. We have what they call the pecuniary interest and the non-pecuniary interests. You understand? Pecuniary interest basically is that the judge, you have the interest of the outcome of the decision. So basically put that in mind, because there is a good case, the case of Leeson versus General Council of Medical Education of 1889. Here the court stated that a person who has a judicial duty to perform disqualifies himself from performing if it has a pecuniary interest or in the decision which he is about to give or renders him otherwise an impartial judge. What do they mean is that once you are in a court decision or you are adjudicating a case and you have interest, a peculiar interest on the outcome of the decision, it is prima facie portrayed that that case you are handling it with bias. What do they mean peculiar interest is that the outcomes of the case, it is favoring you. You understand? That's what basically they mean is that, for example, if you are adjudicating a matter of money or damages, you have an interest on the what? Or when another party. Let me give an example. If you are the judge and the case in court is about land issues, and the land issues, that land that they are fighting for, it was your family land. Basically, that is peculiar interest. You have the interest in the case already. So put that in mind. Then we have what they call the non-peculiar interest. What do they mean by the non-peculiar interest? Basically, here what you have to do or what you have to bear in mind is that, first of all, when you read the Constitution, Article 126 of the Constitution mandates that the courts must be what? Must be independent and what? And impartial. You get? When you did the Libyan what? Libyan Arab Uganda Bank and another versus Abdin Vasilans, they stated that the courts must be impartial. They must not be with bias, or they must not have any interest in the decisions of the what? Of the court. Get? So put that in mind. But however, non-peculiar interest, basically here what they are trying to portray is that, what I can say is that the decision that is in court, how can I say? Let me give an example of a case, a good case here. Here we realize that there is a case, the case scenario whereby we shall see, or whereby we shall put in mind, whereby this case scenario realized that it was an education subcommittee which confirmed the decision by the governor of the school to terminate a teacher's employment. You get? But however, the decision was was quashed by court, because on the grounds that the 3 members of the subcommittee were also governors of the school, which gave to the rise of possibility of bias. Here they say that what you have to know is that these 3 teachers, these 3 members of the committee were also members of the governor, governors of the school. You understand? So after they sat on the on the education subcommittee, which confirmed, which had confirmed the decision by the governor. You understand? This subcommittee confirmed the decision of the governor, yet the subcommittee was composed of members of the governor itself. So they held that there was bias already. The teacher was already dismissed. Remember, it is now realized that it is the governor that is terminating the employment of the teacher. But the subcommittee must confirm. But however, the subcommittee confirming, it is already the subcommittee, they are already the governors. You understand? So already it was already done. There's nothing that was done. So their decision was quashed on grounds that there was a possibility of Of bias. That's the non-peculiar interest that I'm talking about. And the scenario that I've given you is in the case, there's a good case that you have to read. The scenario is in the case of Hanam versus Brantford Corporation. Brantford Corporation. So put that in mind, or bear that in mind. You get? That is all about a non-peculiar interests. You get? There's also a good case still on non-peculiar interest. The case of remedicament. That is also a case of 2001. That is a good case on non-peculiar interest, whereby here that it was still also situations of dismissal. Basically the tribunal proceedings or the proceedings of the tribunal, or the one of the members who was Dr. R was also influenced, had a non-pecuniary what interests in the outcome of the proceedings. So as a result, realized that the decisions was made out of what? Out of bias. You get? Because they say that even Dr. R, who was the directors of the firm, was an expert witness on behalf of the what? Of the applicants. You get? In the case. But however, his fellow board tribunal members, they say that, for him, he said that he said that he will be impartial. But however, it is prima facie. He had the interest. The application was taken for judicial review and it was quashed on failure of the nature of what? Natural justice. So put that in mind, or bear that in what? In mind. You get? So put that in mind. But however, what I can give you as to end this, that's all about natural justice, what you have to know. What I can give is some of the factors for the exclusion of what? For the exclusion of a fair hearing. What do I mean here? Some of the factors that for the exclusion of a fair hearing, we have, we have under legislation when the statute provides for to be dismissed on this and this. Once they come allegation, you are dismissed without a fair hearing. Under employment, they can terminate you. Public officers, national security, emergency, and investigations. There is no need of a what? A fair hearing. The fair hearing can be what? Exempted under those categories that I've given you. But basically, nevertheless, I thank you for watching. Thanks for being on. Subscribe, share the video. Anything that you feel that you are uncertain or you haven't understood very well, please put it in the comment section and we shall come and we rewind it so that we can all understand the concept. You get? Thank you for listening.